Intersección entre secretos industriales y patentes. ¿Cómo y cuándo utilizar estas figuras de protección? Figuras de protección exclusivas o complementarias. Josep Carbonell, Fieldfisher Jausas, España. Margarita Castellanos, Estudio Castellanos, Colombia. Carlos Fernández-Dávila, Fernández-Dávila Abogados, Perú. Moderadora, Margarita Romero, Romero Corral Abogados, Ecuador.
Buen día con todos. Muchas gracias por estar aquí. Qué bueno que nos hayan cambiado las sillas y ahora sean sillones más cómodos. Esta es una charla con otro formato, un panel distinto. Hemos tratado de hacer algo mucho más interactivo y que además permita que la audiencia, aunque poca, pero muy importante, pueda también hacer preguntas y pueda involucrarse en esta charla jurídica que estamos teniendo aquí entre amigos. Primero quiero agradecer a CIPI por haberme invitado a ser parte de este panel. Generalmente es mi socio Alfredo el que está siempre en estas tarimas dando sus charlas, pero bueno, ahí vamos. Quiero agradecer también a mis compañeros panelistas, que ha sido muy grato trabajar con ellos, muy organizados, muy responsables. Y paso a presentarlos uno por uno. Primero las damas, mi tocaya. Margarita Castellanos es socia de la firma boutique de PI en Colombia, Castellanos y compañía. Es abogada de la Pontificia Universidad Javeriana de Bogotá y tiene estudios de especialización en propiedad intelectual de la Universidad Franklin Pierce Law Center en New Hampshire, Estados Unidos, así como especializaciones en Derecho Comercial y Derecho Administrativo de las Universidades Javeriana y Externado de Colombia de Bogotá. De IPPI y del Comité de Patentes de ACIPI. Publica frecuentemente artículos en las revistas World Trademark Review e International Law Office. Bienvenida, Margarita.
Muchas gracias, Margarita.
Luego, a mi diestra está Josep Carbonell Calicó. ¿Está bien pronunciado? Muy bien. Soy responsable del Departamento de Propiedad Industrial e Intelectual de Fieldfisher Jausas en España, licenciado en Derecho por la Universidad Autónoma de Barcelona, adscrito al Colegio de Abogados de Barcelona, máster en Propiedad Intelectual por la Universidad Pompeu Fabra de Barcelona, asesor en Propiedad Industrial e Intelectual de la Confederación Empresarial de Terrassa, miembro de INTA, IPPI y ACIPI.
And finally, we have Carlos Fernández-Dávila.
Abogado.
He's an attorney. He's a founder associate of the Fernández-Dávila as an attorney law. He has been working in regulation. He's an expert in the area of industrial right and competition, health regulations, intellectual and administrative property. He's a member of the Peruvian Association of Industrial Property. He is a delegate of IPPI, co-founder of the Committee of Intellectual Property in INCHAM. He is a co-founder of Contracopia, among others. And even though you all know this, with this we begin. We wanted to try this very interesting topic of the intersection between industrial secrets and patents. And we start with one question. The patents and industrial secrets, are those excluding figures or complementary figures? What do you tell us, Margarita? I'm going to give you a generalized answer to that question. And then later on, Carlos is going to be talking specifically about some data. But specifically, the answer to the question that Margarita just asked in regards of are the figures exclusive or complementary? Well, the answer is not just a yes or no. We need to start analyzing what is the object of protection in both figures. In patents, the object of protection it is a patenticized material that requires all of previous requisites to be able to get a patent. So in that case, we have limited patent. In the case of secrets, it could be information or any other information that has commercial value and that needs to be kept a secret.
Podemos ver
So the first thing we can see is that information that can have a patent is much more limited.
pero que el punto de intersección
But the point of intersection in between both of them
patental
will be the same material.
podría ser objeto de secreto.
I mean, if that material can get a patent, it can also be a secret.
Las protecciones son excluyentes o complementarias.
So when we ask this question, are the protections exclusive or complementary? The answer is, if we have that material that could get a patent and also a secret,
Si se escoge una protección,
whether you choose the protection or not, if you choose one protection, you are automatically excluding the other one. Because if you choose a patent, we will be sharing information. And if we choose to keep it a secret, then you have to keep that secret. So in that regard, both protections will be exclusive. But at the same time, they complement each other. Because if we choose to get a patent,
en general no
patents in general don't distribute all of the information on the development.
ponen a disposición del público
They don't give all of the information to the public in regards to how to produce, how to manufacture a product or a service.
Yo puedo tener una patente
So I can have a patent and keep the rest of the information a secret. And in that regard, both protections are complementary
funcional.
in the way they should work. So now I give the floor to Carlos
Otro punto de intersección entre las
to talk to us about another point of intersection between patents and secrets.
Antes que nada, muchas gracias.
Thank you very much, first of all, to the kind audience.
Pero me pidieron un poco, bueno, nos pidieron al
The panel were asked
de la dicotomía
to talk a little bit about the dichotomy between secrets and patents. And in the discussion with the panelists and in the organization of each one of the talks, we came to the conclusion that maybe there isn't a dichotomy per se. Like Margarita said, when it's about choosing how we protect a specific material or a specific object that needs protection, maybe we are forced to choose between secrets and patents. But when we think more holistically,
un producto,
and we talk about protecting a product,
y especialmente en el caso
there we see, and especially in the case of pharmaceutical products, like you see in the graph here, we see that
arsenal,
we have a really big arsenal of tools of protection and that many of them cohabitate at the same time with each other. For example, the talk is called intersection between secrets and patents. When we talk about pharmaceutical products, I think it is also worth including the protection of data.
sin duda se intersectan.
These three protections are undoubtedly intersected.
Que te acerques un poco.
¿No me escuchan?
No. Es para la grabación.
Ok.
Gracias, Carlos.
Bueno, como les decía, estas
So these three protections that we have here
diapositiva
in the slide are intersected with each other in that area that you see there colored in blue.
y esencialmente en la parte
And essentially, they intersect in the confidentiality that pertains to each one of those. As you can see,
aquella
a
protección
patent is an exclusive protection, a territorial protection that gives you an exclusivity time frame of 20 years as long as you credit all the three elements of novelty, inventive level, and industrial application. However,
la gran virtud
and actually the great virtue of the patent from the social point of view is that the patentable material gets published. That is one of the great virtues of the patent. However, there is a period of time where this information needs to be kept confidential. This is the period of time where the patent gets intersected with the secrets. Well, the secrets are protected, of course, as long as they are secrets, obviously, as long as they have commercial value because they are secrets, and as long as the owners or the controllers of the secrets have taken the appropriate measures to protect that secrecy and that commercial value. In contrast with the patents, those are territorials and of limited duration. Secrets are extraterritorial and they are of unlimited duration or conditioned to something, conditioned to the fact that you need to keep the secrecy. This is where they come together again. And finally, the protection of test data that applies to a series of limited products. In this case, I'm going to be talking more about pharmaceutical products, but as you can see, you also have protection of test data for biological products, agrochemical products.
Los productos o la protección de datos de prueba.
The protection of test data, and we bring that here today because many times in history since the years of 1990, they got confused first with the secrets, and in many cases they were called an extension of a right of patents erroneously. So it is good to have them in the same slide more than once to try and understand where the confusion is. And I think the confusion lies in the intersection, in that blue dot that we are showing here. The protection of test data protects the new chemical entities or biological. We're not going to start a debate here. In some jurisdictions, the protection of test data protects biological and new chemical entities. In other jurisdictions, you have had the differentiation, signaling that once you give protection to test data, this is only applied to synthesis products, but not biological products. So that differentiation has been exacerbated because of the text from the TPP didn't ratify from the USA government. It opens a government of protection of test data precisely for biological entities, separating them from the chemical entities. It's like biological entities are not chemical, entities. But anyways, that's what we have now. So to make it more simple, the protection of test data protects the information that is secure and effective of pharmaceutical products as long as this information has not been shared at the time of the presentation for the sanitary registration or authorization. The difference with the secret is that it's territorial and that it has a limitation of time. In some jurisdictions, like in Peru, you have 5 years from the first world registration. In some others, 5 years from the first registration in the country where you are trying to get the protection. In some others, it can go up to 10 or 12 years. The important thing is that they intersect each other. In all of that says that the material to be protected is a secret or it's confidential.
Gracias, Carlito.
Thank you, Carlos.
Esta información.
That information has been very important about the test data within our panel.
Pasamos a la segunda pregunta.
We go now to the second question. And to my right, I have Josep. Josep, what do you think? What's your opinion? And do you agree with this affirmation? Patents are the tip of the iceberg in a sea of industrial secrets. What do you think? First of all, good morning, everyone. The answer is yes. Evidently, yes. And what better thing than to show you an iceberg? The patent is what we want. The patent obviously gives us the effective and beneficial protection. But in many occasions, it is not the most important thing. I mean, you have information there that obviously you don't want to be patentized because it's going to be known by our competitors or because it cannot be the object of a patent. We also need to keep this in mind because definitely if maybe something doesn't have all of the requisites to get a patent, maybe because it lacks novelty, it doesn't have any industrial application or whatever. The characteristics are very variable, but that information always gives us a competitive advantage, and that is what we want, a competitive advantage. And it's very varied. I mean, you don't have any fixed numbers, even at the level of legal definition. Industrial secrets are very ample. They're very wide. We cannot limit them in any ways, because the parameter is always what gives us that competitive advantage. Definitely, before you proceed, before we try to get a patent, we have to separate what information we are going to add. Evidently, the information is going to be protected, but what information we need to put at the availability of our competitors. As we can see here, inventions, that's just the tip of the iceberg, but many times we don't know the how.
Es trascendental para poder
Like how transcendental it is
de esa invención.
to get the success from that invention. Success both at the level of production processes and also at the level of commercialization or even industrialization. Here, we have prepared a series of cases, and I repeat, this is very generalized. First of all, we have everything that has to do with techniques and knowledge for the fabrication and manufacturing of products, and you include here all of the tests, positive and negative, meaning those tests that have failed. And those tests that have failed could be a part of the industrial secrets because it is information that we used. And obviously, if you put that in the hands of the competitor, now you are shortening the path that they have to take to get to that product. Then the commercial strategies in their biggest expression. Databases are also very important. Locations, we need to know where we are going to manufacture or where are we thinking on manufacturing a product. It is very important from the rentability point of view and also from the point of view of work policies and also at the logistic level. So that information is very important. We also have information, financial information. Where are we going to get the resources from? What resources we're going to get? What channels of financing we're going to be using? That information can definitely be a part of industrial secrets. Then we have providers. Obviously, knowing who is going to provide us those parts for the product, knowing where we are going to buy the raw material, that is a competitive advantage. In the third place, we have
las fórmulas,
the
sabemos la composición.
formulas and the recipes. Obviously, we know the composition, but we don't know the proportion, and we don't know the how to bind that together. And that is always a secret, as long as you cannot get that information through inverse engineering processes. And then we have the code sources, the source code. The source code sometimes is it's what's going to make the difference in a product or a software to give us the results that we want and for it to be attractive for the users. And finally, we find the algorithms. I mean, what can I tell you about algorithms? Technological companies are basically based in algorithms. That is the best kept secret of all. And it's not a part of a patent, first of all, because it very hardly can be a part of a patent.
Te diría que el algoritmo
And I will tell you that, for example, the Google algorithm, the algorithms from all of these technological companies, it's their best kept treasure. Thank you very much. Thank you, Josep. Very interesting. I think
La diapositiva está muy...
if you can take pictures of that slide, that would be very good. It's very important. We move on to the third question, and now we are getting into the topic.
por una
When do you choose one protection over the other, either a patent or industrial secrets? How many customers come to us and ask us just that, right? What can you tell us, Margarita?
Para saber cuándo optar,
In order for you to know when to choose one protection over the other, I bring you 7 elements that has to be considered.
más importante,
The first one and the most important one, you need to see if the information can be patentable, because
fuera
If the information is not able to be patentable, then you would only have a secret.
para ver la patentabilidad, primero pues
In order for you to check on the patentability, you would have to think,
si es materia patentable,
is that invention
de patentabilidad,
patentable? You need to look at the requirements to get the patent.
no se
And in that way, we could analyze that maybe this is not considered an invention.
los descubrimientos, las teorías,
Discoveries, scientific theories, and mathematical methods, laws of nature,
métodos para la
plans, rules, and methods for the exercise of intellectual activities, games, economic and commercial activities, list of clients or providers,
negativo,
the negative knowledge, meaning the way in which something shouldn't be done, the way to present information, abstract ideas, algorithms, or the software in itself.
no puede ser patentable.
None of this information can be patentable, but can be part of a secret.
En la materia hay información no patentable, como por
Also, in material, there are information that is not patentable, like therapeutic and surgical methods and diagnostic methods.
en el Pacto Andino tampoco son.
In the Pact in the Andes,
Entonces,
neither uses or second uses are patentable. So all of this information is actually part of a secret in the case that they have any kind of commercial value. Another point to keep in mind are the requirements to get a patent. And I'm going to talk to you about invention level because it is the hardest one to overcome. If, for example, the information is able to get a patent, but it doesn't have any invention level, then you would only be left with a secret. In regards to invention level, you have to keep in mind that the analysis of invention level
difícil de superar.
is very hard to overcome, precisely because when you filed the application to get a patent and you share the information, we open the door to the examiner to find documents about the state of the art in a retrospective analysis. At the beginning, the retrospective analysis shouldn't be done because the documents that were found should suggest in themselves the combination. But what happens in the practice is that once you have shared the patent in the application, the examiner can find different documents that put together contain all of the elements of the patent.
Invención
So if our invention didn't have the possibility of overcoming an objection of invention level, we could consider to keep it a secret.
es el
About the second aspect is the term of protection.
por la patente.
If we choose to get a patent, now we know that we are going to have limited patent, limited in time. The protection limit will be 20 years from the moment you request the patent. To that, you need to subtract the duration of the process of the application that could go from 3 to 5 years approximately.
Pero sobre el término de protección también
But about the term of protection, you also have to keep in mind the obsolescence of the protection. For example, if you have an invention that can become obsolete in very little time, it wouldn't make sense to get a patent
patente
because
sea otorgada podría
not only, like, once you get the patent, you have to keep in mind that it's going to take a few years to get the patent, and by the time you get the patent, the material might be obsolete already, so it's not going to make any sense to invest time and money to get a patent for that object. In that case, you could choose to keep it a secret until you get a new technology. Another alternative
dar la
is that in order for you to prolong the protection of patents, you need to get a chain of patents, meaning you get an initial patent, you keep the research process, the innovation process,
protección, mejoras a esa
to
invención
make improvements to that initial invention, and in that way to be able to prolong the protection
escalonada de patentes. Igualmente,
in a chain of patents.
pensar en la protección
In the same way, you can think about joint protection to get a patent, and at the same time to be able to keep a secret the rest of the information in such a way that when the patent expires, we still have protection about the know-how,
comercializar.
or the way that that invention is produced and manufactured. The third point is observancy.
Según la observancia, en algunos
According to observancy, in some cases,
o por el
we could either choose the patent or the secret, keeping in mind that some objects of protection with a patent are very hard to enforce.
procedimientos
Such is the case with procedures.
tan difíciles de hacer
Procedures are so hard to enforce in a court
impactando y no encontramos que
that the rules and regulations actually overcome the burden of proof.
de un procedimiento
For example, if you initiate infraction for a procedure, the person that is being sued is the one that needs to prove that they used a different process than the one that was patenticized. But in the Andean legislation, you also have protection of secrets. So the person that's being sued, the accused, can say, well, I'm not mandated, it's not required for me to share my methods because my method is part of industrial secrets. In that case, the owner of the patent wouldn't have any possibility of enforcing his or her patent.
entonces en cuanto a la observancia que
In regards to the observancy, you need to keep in mind that
difícil
procedures are harder
hacer valer,
to enforce. And in the case of secrets,
hay que ver que se manejan de manera diferente.
you have to see that they are handled in a different way because what you are looking for is the illegitimate obtention of information or the violation of a confidentiality agreement.
Que probar
In this case, we would need to prove that there was a transfer of information, of confidential information that was either shared or exploited illegitimately by the accused.
pues las formas de protección son
So the ways of protection are not similar, they are very different.
bueno, otro punto a ser tenido en cuenta es
Another point to keep in mind is the possibility of cautious measures.
mucho que haya
And clients usually are very interested in the possibility of getting one of those measures because that is the most expedited way for the observancy of the right.
si en alguna legislación no
So, if in a legislation you didn't have the possibility of getting precautionary measures to protect the patent or the secret, then you can choose the protection that does come with a precautionary measure. In Colombia specifically,
proteger los secretos,
in order for you to protect secrets or in the action of patent infractions, there is the possibility of precautionary measures. Precautionary measures will be obtained with different proofs, but there is a possibility in both cases.
sigue ahora los derechos derivados del uso
Now, the rights that are derivatives from the previous one, this is a very important point because it talks about the limitation that industrial secrets have. Industrial secrets cannot be enforced on a previous use or independent development, something that can happen with patents. In patents, we see that the first one that filed the request is the one that is going to get the exclusivity right after the procedure, so that person has some power against the previous user. They also have it against a third party that independently develops the invention because the owner of the patent has the exclusivity right against any third party.
empresariales
In the case of the industrial secret, if I conserve my information as secret, my information that has commercial value, but there is a third party that either discovered the secret independently or develops the same information, then I wouldn't have a way of enforcing my secret and I would lose it.
y la información
Because if the information is shared,
secreta.
now the secret is out. The secret doesn't exist.
El siguiente punto tiene que ver
The second topic has to do with sharing of the information, distribution of information. When I say distribution of information, what I mean
con los terceros con la
is,
información que en el caso de los secretos que tanto
in the case of secrets,
se hace pública pueden llegar a conocer.
how much the third parties can get to know the secret with the information that is already out.
Por ejemplo, un
So if, for example, I have a product that I launched in the market,
de reversa.
And you can do reverse engineering to that product and discover what are the elements that are contained there and how they are combined to be able to replicate the product.
Sería
Then the alternative will be to obtain a patent.
con el mero uso
Because with just the use of the information, any third party can already know how to
de caso,
produce it, reproduce it. So in that case, the option will be to obtain the patent in the case of the information is patentable.
también en cuanto a la divulgación,
Also, in regards to the sharing of the information, you have to keep in mind that since patents,
información
they necessarily share the information, what will the third party do with
pueden
that information?
la oportunidad o la ventaja
For example, am I giving my competitors the opportunity or the advantage with a bigger investigation power to take that knowledge that I am disclosing and take my competitive advantage from me? In that case, it would also be recommended to keep the information a secret. So you need to keep in mind up to what point the disclosing of that information in my patent is actually going to bring more damage than good in regards to the capacity for development.
tenerse en cuenta son los
The last point to keep in mind are costs. This is a very important point,
costos para las
especially for small companies
que están empezando
that are still starting in the business
en una patente.
and whose business is based on a patent.
Tienen que pensar
They have to think
que las patentes implican
about the fact that patents come with a cost.
ya la empresa no
Those costs can be very high when the company is still not getting a profit. You have to keep in mind that to obtain a patent, you first have to do research of the state of art, which brings with a cost. Then you have to
la pueda extender a otros países.
do the reduction of the patent in a way that can be extended to other costs. At the end, you have to make a process. You have to process the application, then you have to make the patent international to generate costs in other countries. And at the last, for last, I have to pay an annuity. I have to pay annually. So sometimes it's not possible to get a patent from the economic point of view if we're talking about a small investor or a small inventor or a small company. So in that case, they wouldn't have any other choice but to keep the information a secret if it complies with the requisites to be an industrial requisite, an industrial secret. Thank you. We will go back to you because I have a case that I really like a lot from Ecuador, and we will analyze it later. Carlos, what happens in the world of pharma,
Cuéntanos.
which is your specialty? Please tell us.
Clic.
Can you click, please, to change the slide?
La gráfica acá es importante. Listo. Entiendo, bueno, de acá se ve pixeleada la pantalla grande.
Well, it looks very pixelated, but I think you can see it from where you're sitting.
Acá quería volver
Here, I wanted to go back to what I was telling you at the beginning.
por la dinámica de la charla.
Because of the dynamic in our talk, obviously, we have to face secrets and patents together all of the time, but I wanted to bring to you a case today that actually reflects the strategy of protection of intellectual property for a pharmaceutical product that makes use of all of the legal tools, whether it's secrets, patents, or protection of test data to optimize at a very high cost, obviously, but to optimize nonetheless the protection. So you're going to see, you see at the top line, there is a timeline that starts in -3, -2, -1. In that part of the graphic, the previous phase to the presentation of the request of the patent. Then as of day 0, we have 20 years with the patent protection until the end of the timeline.
En la estrategia de
So
protección de un
in
producto
the strategy of protection of a pharmaceutical product, in the first line over here,
de patentes,
where it says patent,
bajo la línea de tiempo en la parte
under the timeline colored in green,
los posibles desarrollos
I have the possible developments that are going to be protected with a patent,
patente
meaning
de mayor ámbito de cobertura.
the bigger coverage patents or to give it a name, the original patent,
donde sea permitido, ¿no?
and the ones with the Marcuse formula where whenever it is possible. So from the perspective of pharmaceutical products, this is the most solid protection that you can have.
En la etapa de
Then, in the phase of the development of the pharmaceutical product, you have opportunities
formas
to select ways,
idóneas, ¿no?
more ideal ways like polymers, salts, or more ideal formulations
Seguridad eficaz.
to be able to get the most security, efficacy, and security in the manufacturing product. And all of that is also patentable, especially also the synthesis procedures and the formulation procedures. And finally,
Del producto farmacéutico al mercado.
following the launching of the product into the market, I have the possibility of getting a patent for the therapeutical methods and the uses and second uses in most of the jurisdictions, even though in the Andes community is not the case. This is at the level of the patents. This gives us a very wide scope of protection for pharmaceutical products, but we don't just stop there. We can use the test data and the industrial secrets. In the second line, we have test data. Obviously, test data protect specifically the pre-clinical trials in some institutions and the clinical trials in all of the jurisdictions where this protection exists with an exclusivity period of time. And that protection is generally starts with the registration of the pharmaceutical product in the year number 12 or number 13 approximately, and then after that I can commercialize the product. In Peru, we have 5 years of protection since the first world registration. In other countries, you can have up to 10 or 12 years of protection ever since you invoke the protection in the territory of destination. This implies some kind of extension of the patent. When you look at it, first of all, because you are protecting an object or a material that is not being protected by a patent, and those are clinical trials to give security and efficacy to pharmaceutical products. And lastly, talking about the industrial secrets, in the third line,
Como bien dijo Margarita,
like Margarita said, if I'm not mistaken, in the green phase,
tenemos en muchos casos
we have in many cases hundreds up to thousands of synthesized molecules to be able to get an apparent candidate, or maybe one or two or three candidates. These molecules that are selected, trying to find the object that is going to be developed,
una patología.
that is to try a specific pathology,
Con ese criterio para
they are selected with that criteria to be patentable, but there are some others that are not in compliance with the target. They are not selected for a patent, but they go to other lines of investigation. Because they go to other lines of investigation, well, they are kept a secret, and that is the ideal protection for those molecules as long as they are identified as a candidate for a possible line of development, maybe in other disease, in other pathology. So those molecules that could be potentially pharmaceutical products, at least in that initial phase, are not patentable. And you can have many, and actually we do have many that will never get a patent, but they are kept a very well-kept secret.
Más adelante tenemos
Then later on, we have the opportunity of using industrial secrets
la etapa de desarrollo, ¿no?
also at the phase of the development, especially for synthesis, optimized synthesis methods,
Se puede proteger por patente también, ¿no?
and something that could be protected with a patent as well. However, it can be very costly,
Como ustedes saben,
or it might not be necessary because, as you know, when I reinforce a synthesis process, I do it in, a few ranges. I'm not obliged to disclose the ideal one. I give a range and I present my experiments at the extremes of that range. But if I continue with the investigation, I can optimize those ranges or even find the perfect point. But it's not a requirement for me to disclose that or to get a patent for that, so I might keep it a secret. Actually, it's very frequent that it's kept a secret.
no sean
And
públicos.
obviously, if this information is not published in any pharmaceutical magazine, you have all of this as secrets.
Explotar el
That is also another opportunity to exploit industrial secret when you talk about pharmaceutical products. And of course, once the product is launched, just like any product, it's going to be protected. The commercial strategy, the marketing studies are going to be protected as secrets, the financial information, the cost structure, the strategies, etc.
Estamos hablando
So as you can see, we're talking about just one product, X product, for example, and it has countless number
de un sinfín de oportunidades para
of opportunities to be protected, countless opportunities to get profit.
que esta
So with this, I just wanted to let you know in a graph that
del objeto
if we talk about the material or the object to be protected, sometimes they compete with each other. When we talk about the product and we put it face to face in a holistic way, we can use many tools of protection. Margarita. Thank you, Carlos. Yes, precisely. I do think that one of the anticipated conclusions of this panel is that when you have a client with an invention or a product or a procedure, you have to do a very extensive analysis.
al panel
I wanted to bring to the panel a case from an Ecuadorian that discovered
un procedimiento
he worked in a procedure
de una crema de ozono
to obtain a cream of ozone cream through some oils. Here I have it.
y
This is the title.
and treating compounds from ozonized anciatura. Bueno, en fin, un método
A method, a different method for manufacturing an ozone cream. And at the end, the counselors that were working with him decided to go for a patent. They decided to request a patent for the procedure, first in Ecuador, then I think they filed a PCT, which is the number that you see there in the screen.
y al final lo
And at the end, he was able to get it in Ecuador. He got the patent.
creo que en los demás
I
países
think in the rest of the countries, he couldn't get it. And at the end,
porque no
in Ecuador, it expires. It expired because he didn't keep paying the annual fee. But what is the bad thing about this? That the commercial value of this product couldn't be monetized. He couldn't get any profit out of it because what we did was he exposed, he put it at he made it available for the world how to do the procedure.
al inicio.
So Margarita, can you please confirm all of these rules that you mentioned at the beginning? What should have been done in this case? In this case, we can clearly see that there was a mistake
La protección utilizada
in the protection that was used.
titular de esta patente
Because the owner of this patent, he got the patent for the procedure, but he couldn't get the patent for the product that was obtained because of that procedure. So what happened? He disclosed the information on how to use the product, on how to get the product. And then after that, it's going to be very hard for him, the observancy of the patent. Because as we saw before, the procedures are
de ganar en
very hard
infracción.
to win in the case of infraction.
Por el lado de la divulgación,
So in the case of disclosing information, he disclosed some information that he should have kept a secret because procedures are very hard to do reverse engineering. So that is
secreto,
that's another feature, another thing you need to keep in mind to go for secrets instead of patents.
conserva.
Maybe I can keep this a secret, and in that way I can keep the information protected far beyond the duration of the patent. So the term of protection had to be kept in mind as well, because if you keep the information a secret,
La protección es,
then the protection is unlimited.
pues ya vimos, la observancia era complicada.
So obviously the observancy was going to be very hard. He disclosed the information for his competitors. They did everything wrong. The costs,
Además,
yeah, the costs.
la ley
if you have a patent that you cannot, come to, you cannot make material, then basically you just lost money.
plata en la patente.
You lost the money in the patent. It didn't make any sense because you couldn't get anything out of it.
Protegido por patente de producto.
Could he have protected it?
Sí,
Maybe he could have protected it with a patent of a product, but you already had some ozone creams. When you analyze the factors in this patent, you can see that you already had creams made of vegetable oils with ozone
que sirven terapéuticamente.
that are used therapeutically. They were already in the market. They already existed.
Fue un proceso
So what this inventor discovered, he discovered a procedure that made the product more stable due to the manufacturing process.
Más o menos como que el señor se podía haber hecho millonario si en vez de hacer
So if instead of getting a patent, he would have kept it a secret, he could have been a millionaire, basically.
para ejemplificar lo importante.
This is just a small example on why it's important to choose the best way
Bueno, pues
in regards to protection. Let's go now to our fourth question.
pedirles a mis panelistas
I wanted to ask the panelists if you can quote a few ways or recommended practices to preserve industrial secrets. Josep.
España
In Spain, Spain has a law
viene a regular todo lo que son los secretos
that regulates all of industrial secrets. This is the 1-29 law,
19, mejor dicho, creo que
actually 1-19,
de la Unión Europea.
and it's in the directive of European Directive in 2019
Artículo 39
that is there to develop Article 39.2 of the ADPIC.
por el compromiso del ADBIC
So we are included in the ADPIC,
ha venido a definir y a regular
and what they define and what that basically they are regulating and creating the rules and norms for industrial secrets. What is an industrial secret? How is it defined? It has a very wide definition. It's all information, all scientific and technological, industrial, commercial knowledge, organizational or financial, meaning everything that has some value. There are also some objective requirements that are established. Those are, first of all, needs to be a secret. I mean, it cannot be of public dominion. We cannot base a secret in information that is already out there.
no podemos exigir.
And that in some,
Valor empresarial. El valor
it needs to have industrial value, maybe in the present, maybe currently, or maybe in the future.
ese valor competencial
Because that value that we have needs to be real, or
y es
whether short-term or long-term.
fácil cuando estamos hablando del
And that is also very easy when we talk about the industrial context, but it also has a personal implication.
a ciertos actos de las personas
Information in regards of the acts of certain people that are part of a company can be a part of industrial secrets. The separation of the major stakeholder in a company can be a part of
en tanto
industrial secrets as long as that knowledge
gananciales, pues puede tener un impacto en bolsa que puede hacer decrecer.
can have impact
Y lo mismo podríamos decir de los
that can increase the profits. We can also say the same things about influencer.
conociéramos ciertas actividades personales
If we know certain personal things about influencers, they can have their business affected. So in many cases,
porque está
the circle that is behind or the team that is behind influencers have some confidentiality agreements that are brutal. They cannot give out that information. The third requirement or objective is that it needs to be protected.
o el titular de esos secretos
The owner of those secrets
creado unos mecanismos
needs to create some protection mechanisms like regulated accesses to the information. The information cannot be, available for everybody.
de círculos reducidos y sobre todo que
We're talking about a reduced circle of people that can access the information, and the people need to know, that they are working with industrial secrecy and they cannot reveal it, they cannot disclose it. Who can be the owner? Well, a lot of people could be physical and
excepciones, ¿no? La primera excepción es
physical person and legal person. And obviously there are exceptions like independent discoveries. Obviously, any person that gets that information through an independent procedure, an independent tool could do it. We're not talking about industrial secrets. Industrial secrets are not erga omnes rights.
también ahí entraría
We obviously now have procedures of reverse engineering. If we get the product and if we can know what it is and how we can get it, well, that cannot be protected by industrial secrets.
los derechos
Then we have the exercise of the rights to workers.
alegar derechos
We can't claim industrial secrets to
tampoco
violate the rights of workers or any legal practice either.
una cesión, una autorización o una licencia.
If I have an authorization, if I have a license to be able to exploit that industrial secret, of course I can do it. It's a legal practice. We also have some exceptions.
El secreto empresarial que se obtenga
All industrial secrets that is obtained as a consequence of freedom of speech and freedom to information cannot be limited. It can be used. Also, if it's in the defense of the general interest, meaning we cannot claim industrial secrets
un acto ilícito
to not disclose an illicit act.
empresarial,
We cannot say, well, this is an industrial secret, so I cannot disclose it. No, if you have an illicit, an illegal act, no, you cannot use industrial secret. The same thing happens with legal representatives. If you have information from legal representatives, from the workers, that the workers are making available to them in the defense for their rights, cannot be defended by industrial secrets. We also have legitimate rights. We cannot claim industrial secrets in order for us to not be compliant with the rules or the regulations.
puedo explicar
We cannot say to a judge, well, I cannot explain that to you because it's an industrial secret. I mean, no, those are the exceptions. A passive subject is any person that is mandated to not reveal, to not disclose. But the law introduces a figure that is the employer as a third party, a good faith third party. And that is a figure that
funcionaria.
it is a very revolutionary. It's very revolutionary because
Que es
the ownership of information that is the object of industrial secret by an employee
puede poner en problemas. Él es el
can bring problems because that person is responsible. What does that do? That at the time of
emplear a gente,
employing people,
un disclaimer de
you
hoy
need to give them a disclaimer of you're not going to take any information that is the object of industrial secrecy from your previous company and bring it to my systems because now I'm responsible.
sí, o sea, sencillamente un listado de clientes que
And you need to have a list of clients that are protected. If they are protected with industrial secrecy, that can get me into trouble.
respecto
In regards to
a lo que es la naturaleza del derecho, bueno, es transmisible, puede ser objeto de tutela,
the nature of right, it's
se puede
transmissible. You can get licenses. It's basically the same as with the patent. You don't have a lot of limitations. The disposition acts are exactly the same. The actions for civil defense, the civil defense actions are very similar or practically the same as the ones that are contemplated in the law of patents. In one side, we have the active legitimation. I mean, the owner of those industrial secrets.
tenemos
And the passive ones, we have who is mandated to not disclose those secrets. And the third one, like we said,
hacerlo de buena fe, que no está, pero que sí
the good faith person.
o se utiliza esa información
That person is not included there, but it can use that information.
declarativa.
The actions are, well, declarational, apprehension of the merchandises, removal, attribution of property to the demanding of those objects that or products that were manufactured using their industrial secrets, indemnization for damages, publication of the sentence, and then the calculation of damages. So it's basically the same system that protects the patents, the general costs for defense, the costs for investigation, obviously, the costs that you have to
de esa vulneración de
use to know the sharing of those secrets, the
explícita a la ley de patentes para el cálculo de los daños y perjuicios
you need to calculate the damages, and using those damages, to pay the benefit
o, en su caso,
to the person that was violated or infracted.
también es importante tener en cuenta la
It is also important to keep in mind the prescription.
Tenemos 3 años para poder actuar
We have 3 years
conocimiento
since the moment
de la utilización de esos secretos.
since the moment we find out that those secrets were used,
Ese plazo,
and after that time frame is over,
la utilización o todo lo que conlleva la utilización
the use or everything that has to do with the use, well, it's over. We cannot do anything about that. Thank you very much. So we have a special law, a specific law for industrial or commercial secrets in Spain. And who knows those actions?
los mismos tribunales
The courts. The courts are the ones who, everybody that works with industrial property, we have an ordinary jurisdiction that works with everything that has to do with industrial and intellectual property.
los juzgados de lo mercantil en
And within those courts that works with commercial,
especializaciones hay juzgados de
we have specialized courts. We have a court for patents, for brands, for competition, and for secrets. Well, I'm very jealous of you. Let me tell you that in Ecuador,
También habla de la
there
información
is a code that talks about non-disclosed information.
de
And we have a procedure
quería yo
for industrial secrecy.
incluir
I wanted to talk about this and include it in this panel. As you can see there, it is a very quick procedure. You ask a notary
lo del secreto y un sobre sellado.
to give you the secret in a sealed envelope. You pay the official fee. The notary orders it officially, and you send it to the National Organization for Industrial Property. Then the notary sends the filing, the request with the fee.
También tiene
We also have another law that has articles that regulate commercial secret.
preparando el panel.
But when preparing the panel, we discovered a novelty in Peru
Que Carlitos
that Carlos Fernández is going to tell us more about.
Sí, claro. Discutiendo esto que menciona Margarita,
Yeah, well, like Margarita said, in Ecuador, this procedure for the filing of a secret, I remembered something very similar that happened in the year of 1990. It was a case that we worked based on those regulations.
está derogada por la decisión
That regulation is on decision number 4806, but it's still effective because Article 127 from the Law of Intellectual Property from the year of 96 established
recurrir
that you could go to a notary and deposit an industrial secret in a sealed envelope
lo guarde en su
for the notary to keep it in their vault. And at the time that you have a litigation process, we could have clear proof
secreto en el momento en que lo depositó ante el notario. Entonces, básicamente,
that the plaintiff was protecting that proof at that time.
ese secreto,
So basically, that's what we look for when you protect that secret.
por la ley del notariado es posible hacer ese tipo de depósitos
We can still, because of the notary law, we can still do those filings, not only to keep it at the custody of the notary, but also at the custody of the controller.
información
So I go to the notary, I deposit the information within the envelope, they seal it, they
guardo para
keep it in the record,
litigar.
I take it home, and then I keep it there for when it's time for me to go to a litigation.
Todos los días es poco práctico.
You know, if I had to do that every day, it's not very practical, but it's one of the many layers of protection, one of the layers of protections or measures that you take to protect industrial secrets. You know, it's very layered. The first layers are physical measures. This is a physical measure that contributes to of a clear proof to that effort of protection. Next one, please.
Pero también sirvió para algo más. En este
But it was also good for something else. In this case, that is also very old, with a law of disloyal competition, it was also derived, but I bring it into account because it's important.
en Ecuador,
And it has to do with the situation that happens in Ecuador.
frecuente ver este
It's not very frequent to see these kinds of deposits right now. It was very frequent in the years of 1990s and the beginning of the 2000s. It was because we didn't have test data protection back then. So in the case of files or records of agrochemical registrations, especially in pharmaceutical products,
hacer este depósito.
it was kind of trendy to do this deposit, and it was very useful, for example, in this case. Not only was it easy to prove the existence of measures to preserve the secrecy or the confidentiality of the secret, which is
Margarita bien lo
one of the loopholes in litigation, like Margarita said,
defender
to
enforcement de un secreto empresarial es complejo, ¿no?
to defend to defend industrial secrecy. It's very, very complex. It's in my opinion, it's a lot more complex than to defend a patent. It's more intense. It is less certain. It has more unexpected things. So in this case, the deposit facilitated the proof of the rational effort or the effort to protect the secrecy.
El depósito
But also the deposit what it did was
la información
to prove that the information that was contained in that envelope was controlled at the time of the deposit by the plaintiff.
esa prueba era fehaciente porque era una prueba notarial.
That proof that was irrefutable because it was a notarized proof.
Por el denunciado. Y el denunciado o la actividad
It could not be challenged by the accused.
es de, número uno,
What they claimed was, number one, he needed to prove that he knew of the secret before me. He had the burden of proof, not me. Once I had this deposit and I presented it to the authorities, the burden of proof was
al denunciado.
on the accused.
Sí, antes que yo,
So he had to prove that either
o yo
he knew it before me or that he developed it on his own,
de la protección, o que yo se lo cedí.
or that I gave it to him, or that a third party gave it to him. If he couldn't prove that, he will lose the case, and he lost the case, right? It was very, very easy once you have that deposit. When usually to litigate a secret it's very, very complex.
Pero sirvió bien.
So in this case, this physical deposit was very, very useful.
Saben, Margarita
As you know, Margarita Castellanos is the one with the most wisdom in this panel. So
las pautas.
she's the one that is going to give us the guidelines and the recommendations that are required for interested clients for the best practices in industrial secrets.
Bueno, yo les voy a hablar de unas recomendaciones.
I'm going to tell you about some practical recommendations to keep information a secret.
Lo primero que se recomienda
The first thing we recommend is to do an audit of the industrial secrets.
lo que tomamos en cuenta son unas
What we do for that is to ask some questions to know whether or not we have industrial secrets.
preguntarse
The first thing we need to ask is whether or not the information is known outside of the company, by whom and to what extent.
dentro de la empresa,
If it's known inside, within the company, by whom and to what extent. What steps or what actions have been taken to keep that information a secret? Because I have to prove at least that I have taken some reasonable measures to keep that information a secret.
información
If the information represents a competitive advantage,
medir su valor
if its value can be measured, because for the information to be considered industrial secrecy, it needs to have commercial value. So can I determine what is the value of my secret? And you also have to keep in mind how much has it cost me to keep or to obtain that information, meaning resources in about time, investing, people, etc. And finally, how hard would it be to duplicate that information with the information that is made public? This is what we saw again with disclosing. Once I disclose just the necessary information that I need to put at the disposal of the public, how easy it is to duplicate that information by a third party.
Bueno, el segundo punto es las políticas. Una vez
The second point is politics. Once I determine what is my secret, what is my industrial secret with commercial value, now I need to establish some
mis empleados,
policies with my employees. These are policies of handling of the information,
manejo del internet,
handling of the internet, handling of communications, of email, social media, etc., to be able to control that information
pública.
in a way that it cannot get publicized. After defining the policies for management or handling of the information, once they are all defined, now you have to do training. You have to train the new employees that come to the company to make them aware of the policies of handling the information,
Para hacer
and frequent trainings
y hacer valer
to keep the information a secret over time and to be compliant with those policies that have been redacted.
sería la clasificación.
The second step will be classification of the information, classification and labeling of the information. You have to label all of the information that you consider to be confidential. About labeling, it is important to establish that once you do the audit, you determine what is the information that is secret. The labeling has to
Auditoría, es decir,
correspond with that audit. You have to label as confidential the least amount of information possible.
después viene limitar el acceso a la información.
After that, you have to limit access to the information. The criteria to limit the access is to determine whether or not the person really needs that information. If they don't need it, then they don't get it.
Después vienen los acuerdos.
After that, we have confidentiality agreements,
La medida más importante,
which is the most important measure
información secreta.
to keep the information as secret and be able to
Entonces,
enforce industrial secret in court. So confidentiality agreements can be established with the employers, the contractists, and third parties, and this is the most important measure to keep the information a secret. Inside of work contracts, you already have some clauses for confidentiality. Employees cannot disclose confidential information, and this obligation in the work contract goes over the termination of the contract. So, talking about the employees of the company, the owner of the information is protected in part by the work contract. But it is always important to establish those obligations of confidentiality specifically within the contract.
si los contratistas
Talking about third parties and contractors are not covered by the work contract, it's even more important with these people to establish those obligations for confidentiality specifically in a contract.
es también importante
It is also important to highlight
que se nos puede olvidar y es
a measure that we might be forgetting, and that is
los empleados.
doing interviews at the time of termination of the employees. At the time that an employee gets terminated or they're leaving the company, the exiting interview for that employee is the last opportunity the employee has to speak to this person. And this is important because you need to make clear, you need to let them know what are the obligations of confidentiality that go beyond the work contract. So in this interview, you can know if this employee is going to be working with one of our competitors, if they are going to open their own competition, their own competitor company,
Que las legislaciones
due to the fact that legislations in general do not foresee the possibility
Entonces,
of getting into an agreement of non-competition. So once the contract is over, the person is able to work as the competition.
claro,
So we have to make clear that even though I cannot
la misma
forbid you from doing the same activity,
obligaciones
I can enforce the obligations of confidentiality that go beyond the work contract. So this
empleados
last interview
tener como finalidad
with an employee
esa obligación.
should have the goal of establishing the reach of that obligation and the confidentiality agreement, and it should be recorded, by the way.
Bueno, después de que hablamos de,
After we talk about policies,
también están las medidas ya,
we also need to talk about the tangible measures to protect the information.
pues las medidas son en primer lugar el monitoreo de dónde
The first one is monitoring. You need to monitor of where you keep the information. You need to know how many computers, how many laptops you have, who has that laptop,
y en general todas las formas.
and you need to know every way in which the information could be copied.
La segunda medida
The second measure that it's very obvious is to ensure all of the computers with at least a password before you have access to the information.
dependiendo
Security, depending on the size of the company, you might have security lockers or some restricted access offices where you keep this confidential information. It is also very important to limit the access to third parties to the company and to have a registration of everybody that goes into the company and who they are going to be meeting, so you can have a safeguarding of the information. And the last point is to be careful internationally. When the company has international relationships and the information goes out of the country,
los países no
you have to keep in mind that maybe in other countries you don't have the same legislation to protect the secrets. So you have to be very careful with the information that you transfer internationally. Thank you, Marga.
La pandemia,
I think with the pandemic, it's very important nowadays. Everything is digital. Those of you that didn't do that before are doing it now. Some people are starting to get digital now. You digitalize information about processes, client lists. I think in a law firm, almost all of the information is valuable, and it should be
dar el tratamiento de información
treated as a secret, as commercial secret.
para que tomen las medidas adecuadas.
So now it's up to you. You need to be able to take the proper measures. Finally, in the last part of this panel, we wanted to talk about practical cases in different areas for you to analyze and listen to what our panelists have prepared.
Casos de estudio que puedan
Case studies that could be exposed to analyze the options of protection of industrial secrecy and patent and the complementation of these two institutions.
primero.
Ladies first.
Tocaya.
Bueno, como caso de estudio,
As a case study,
yo traer
I thought of bringing here
actividades que
the case here of the flexibilities that we thought about the patents with the COVID-19 vaccinations. We thought it was important to establish licenses, the obligation of the patent rights,
las vacunas para
to make it possible for third parties to reproduce the vaccination to, guarantee the population health. When we analyze that case, we realize that, precisely we can see here the interaction between secrets and patents, because yes, we do have patents on some COVID vaccinations.
es parte de
The information that is part of the patent
toda la información
doesn't cover all of the necessary information to be able to reproduce the vaccine
y
in an effective and safe way,
salud
and that guarantees the health of the people that use them.
es que la
What I mean is that the information included in the patent doesn't give a third party a possibility to be able to reproduce and commercialize a vaccine. All of that additional information that is part of the secret is not going to be able to be licensed
o o realizada.
or is not going to be able to be used if you limit the rights of the patent. So in conclusion, as much as you gave mandated licenses
Los derechos de exclusividad de
or that you gave exclusivity rights in patents,
producir una vacuna,
it still doesn't solve the issue of a third party reproducing a safe vaccine
que se encuentra
with the information that you see in the patent request.
la patente debe divulgar la forma
Yes, the patent needs to disclose the most ideal way of creating the vaccine or creating the invention
esto
to make it possible for a specialized person in the subject to be able to reproduce it. This rarely happens because people keep the information for themselves. And on top of that, you have a lot of additional information on the know-how, the negative knowledge that is kept a secret, everything that has to do with the infrastructure to be able to produce it and the commercialization information that is not going to be disclosed with a patent license.
Que quiera comentar
Anybody has a comment about this case, this practical case
patentes del COVID.
on COVID patents?
Que Moderna brinde una
Modern gives a detailed description on the process
al desarrollo de la vacuna.
that got to the development of the vaccine. How do you solve that, Margarita?
pues lo que yo pensé frente a
What I thought about that is that
empresas como Moderna ya
companies like Moderna have been developing for 10 years the RNA technology, and that information is not going to be displayed in the patent. All of the infrastructure, all of that experience to be able to reproduce it,
comercializar
the way you commercialize it, you commercialize the vaccine, doesn't have to be in the patent request. That information is not going to be public.
las medidas frente a la patente no van
So the measures before the patent are not going to guarantee a third party can commercialize the invention.
Gracias, Marga.
Thank you, Margarita.
Sí,
claro.
Alfredo.
Esta exigencia que es como un requisito
So this requirement is of a best mode
la invención baja
of doing the invention.
acciones
Is it going to generate, in some cases, some kind of annulment processes? And maybe Carlos can let us know something about this. In the case of pharmaceutical patents, most cases of the annulments are precisely because of that. Companies of generic medication, competitors,
innovación
are trying to get close to those innovations. They do it through annulments.
nulidad del best mode
What is your opinion about the annulment figure or the best mode figure as an open door to be able to use that technology?
en legislaciones cuando hay el best mode
Yes, in legislation, when you have the best mode, that can be a little bit more complex, and it can an annulment can happen.
que yo no tengo
But anyways, you have additional information that I don't have to disclose, like the raw materials, where do I get it from, who do I buy it from? All of that information is information that I don't have to disclose. Maybe the patent can tell you what's the procedure, what is the temperature, what amounts. Maybe I do disclose the best mode, even though in the legislation we also say that a third party that is good in the topic
en un laboratorio
can do it.
realizar.
Maybe a third party can get it in a laboratory, but for them to do it in a big scale, to commercialize it, to have the infrastructure, to have the money to be able to produce it is not that easy.
Carlitos, ¿quieres complementar?
Do you want to complement that?
Es algo que sabemos perfectamente, ¿no?
Yes, we know that perfectly.
El best momento de presentación de la solicitud
But at the time of the request for the patent,
de desarrollo
a lot of the development happens later on, like I put it in the graphic, in the slide.
lo señalan con un aforismo los especialistas, ¿no?
Specialists usually talk about this
Productos biotecnológicos,
with an aphorism. In the case of biological, products, The process is the product. From one plant to one plant, you can have the same product with the same specifications, but you still have variations.
Digamos, el desarrollo del proceso
The development of the process,
en
especially in pharmaceuticals, biopharmaceuticals, doesn't end. It doesn't end with the process that has been patented, but with a lot of other processes because they get developed industrially with practice and experience.
rangos, ¿no?
In the patent, all you have is the initial processes, but the most optimized way hardly gets patented. It's usually kept as a secret.
Práctico justamente en esta.
Actually, let us know about your practical case in this area.
Estamos mal de tiempo, ¿no? Pero
Estamos mal de tiempo, sí.
vamos a
Yeah, I think we are short on time. Let's go ahead and do it quickly. I couldn't find a case. This is a real case, a real life case. I couldn't find a case with a conflict in between patent and secrecies. This is just a typical case on secrecy. The important thing about this is that it's very recent and it has very two interesting conclusions, I believe.
caso donde un trabajador
It's a case where a worker from a company that
esencialmente logístico
gave logistics services essentially to other companies. This worker leaves the company, and 3 or 4 months after that, it's hired by the competitor.
y luego de trabajar año y medio sale
After working for a year and a half, he leaves that company. All of a sudden, the original company denounced or sued this ex-worker for violation of secrets before the Commission of Unlawful Competition, arguing that this employee extracted secrets remotely, electronically, using his old password,
de antiguos compañeros de
passwords from other previous colleagues,
terminal de una expareja.
using the computer of an ex-partner. They filed as a proof the testimony and the computer from the ex-partner, the ex-girlfriend. It's also very interesting. They hired Ernst & Young to do a forensic audit on the computer of the ex-girlfriend that determined the place, the way, the how-to, and the date of the 3 different accesses that this ex-worker did
A efectos de obtener esta información confidencial y coincide
in trying to get this confidential information. And those dates coincided with the participation of the new company that employed him
con la
in different competitive litigations with the original company.
¿no? Rescatando algunas de las cosas que conversamos aquí sobre las medidas.
So going back to a few things we talked about here about the protection measures you need to have to keep the confidentiality of a secret.
Mantenga su protección legal. Y les decía hace un rato que era por
If you wanted to keep their legal protection, I told you before that it's very layered. We said before the first layer is physical, like keys and locks, vaults, notaries. There's a second layer which is technological. You have to do encryption, encryption of messages, passwords, etc. And there is a third layer, which is the legal layer, which was very clearly exposed by Margarita, like confidentiality guidelines, termination interviews. What is interesting in this case is that in those resolutions, they didn't argue the negligence that the original company had
anular la clave
when they didn't actually cancel or reset his password. The negligence that they had when they let a logistic worker having access to the passwords of other workers, that wasn't argued in the case. So they didn't. They were not talking about the fact of whether or not the company took the appropriate measures. They talked about the politic of contract, the work agreements, the security system of the original company, but they didn't argue the negligence that this company clearly had.
que yo rescato de esta
2 things I can take from this resolution that were very interesting to me. First of all, and it's logical,
no forzaron a la compañía
they didn't force the original company to prove that there was a secret.
Es algo, a mí me parece la prueba diabólica en esencia, ¿no? Porque probar que algo es secreto es probar que no ha sido divulgado, es la prueba de un hecho negativo. Entonces, se asumió en abstracto por la naturaleza de la información.
So they assumed, because of the nature of the information that the original company was claiming that was abstracted from them, it was,
En consecuencia, sí,
implied that it was confidential. So basically, if it complied with the characteristics, it deserved protection.
y trasladó la defensa al denunciado.
Now they put the burden of proof into
Lo que me pareció
the accused.
resuelve mucho de los problemas que el litigio de secretos a nivel de
And I think that's interesting because it resolves a lot of the issues, a lot of the complexities that this kind of litigation brings. The other thing, one of the defenses from the second company was, I didn't know.
Sabía que este señor
I didn't know that he subtracted information, confidential information, and that he used it in my favor.
no me favoreció porque yo perdí la
Actually, he didn't do it on my favor. I wasn't benefited because I lost the litigation.
¿no?
So
Les leería, pero me olvidé mis anteojos. Básicamente la comisión
basically, the commission said,
no
the company is responsible. I don't have to prove that the company knew it or that the company had to know or that they were negligent. It's enough for them to prove that the company was responsible of this employee, that the employee was a subordinate, and with that, the company now has the liability, has the responsibility, and because of that, they were sanctioned. Finally, the company said, which I think is also very useful for the litigation process, finally the company said,
pero no tuve beneficio.
but I didn't have any benefits. I didn't obtain any benefits. And usually in the copy, in the competition agency in Peru, when you go to a litigation in cases of disloyal competition, when determining the amount of the fine, you have to determine, among other things, how much was the illicit benefit. In this case, you had so little proof, you couldn't determine what benefit they got. So the commission turned it around. They turned it around in the requisite of illegal benefits, and they said that in this case, it was best to go not only to
De fiscalización, ¿no? Que es otra de las características que utiliza la comisión para
how hard it was for them to, get profits, but to the potential damages, not just how much benefit they got illegally, but how much benefit they could potentially get.
potencial daño a la sociedad.
Not just to the owner of the secret, but potential damage to the society, because the commission said the violation of secrets doesn't incentivize innovation. So when I don't sanction the violation of a secret, I am punishing innovation. And that is what I wanted to let you know about this resolution that was very interesting to me. Thank you, Carlitos.
3 minutos.
We have 3 minutes,
Rápido.
so I'll go faster.
Bien, el caso que os presento,
The case I'm presenting here, it is a media case.
intentaremos ir lo más
I'll try to go as quickly as possible.
Super López.
This is about Super Lopez. Who was Super Lopez? Super Lopez was a Basque engineer.
En las circunstancias entró en una multinacional.
Because of the circumstances, he got into General Motors, a multinational, and he got into very big positions. And what was his position? He had to create organizational systems for the production of cars.
Muchas de las prácticas
A lot of the practices that are applied nowadays, the assembling chains, the supply chains, come from Super Lopez. He was a key figure in General Motors, and he was very influencing. He had a lot of power to the point that, yes, he was 27th at the practical level. He was actually number 2 within the company. And what did that do? What did that generate? Well,
de las luchas políticas.
in a way, he got tired of political struggles in General Motors. Also, his woman didn't get used to move to Detroit. She wanted to go back to Europe. And third of all, he got disappointed. He wanted General Motors to open a factory in his country, his home country. When he found out that wasn't going to happen, he got very disappointed. And along with all of the other problems that made him get in contact with Volkswagen, Volkswagen obviously offered him almost 10 times over what he was earning. But that's not one of the reasons why he left. The reasons were the ones that I told you before. And we're talking about the year of 93. He actually got General Motors to have very good numbers. So he was going to replicate the same thing in Volkswagen. He was sued by General Motors for industrial espionage and subtraction of documents. What did he steal or subtract? A list of manufacturers, the planes from a factory to open a new factory in Europe, and also the theoretical and conceptual information of a new model that's called the load cap. So with that, the very long procedure started in Germany and in the US. Very aggressive procedures where they were demanding multi-million ciphers, multi-million numbers. At the end, they agreed, they settled, and first of all, Volkswagen paid $100 million to General Motors. The second thing that happened, this agreement included General Motors demanded the immediate termination of Super Lopez, and we're talking about 1997. And finally, the commitment from Volkswagen of acquiring supplies from General Motors in the costing $1,000 million, when actually at that time it was backwards. The supplier was Volkswagen to General Motors and not the other way around. So what is the conclusion here? That industrial secrecy, the revealing, the disclosing of industrial secrecy comes with consequences, and it has very important consequences. So thank you very much.
Me he quedado a cuadros con las cifras.
I am very shocked with all of these numbers. Thank you very much. Carlos wanted to tell us a little bit of this protection through industrial secrecy from in the copy. I just wanted to recommend you this guide. It is a guide on protection for industrial secrets. It has a chapter within the guide where they establish the dichotomy between patent and secrets and when to choose either or. It even has like a tree for decisions. I'm not going to stop here, but it's very, very useful when you read it quietly at home. Not for a presentation, but I recommend it to you. It's a good read. For a night of insomnia, I recommend it to you. Thank you very much. I don't know if you have any questions. Anybody wants to ask something?
Muchas gracias. Excelente.
Thank you very much. Excellent. Your panel has been very practical. My question is for any one of you. How much do you recommend to your clients the use of digital records, both public or private, as a constitution of proof of commercial secrets?
Fabri, ¿puedes repetir la pregunta porque con la mascarilla no se te escucha?
Okay, sí. ¿Qué tanto recomiendan a sus clientes?
How much do you recommend to your clients the use of digital records like WIPO proof, for example? I know it's been discontinued, but there are others as a constitution of proof in the case of commercial secrets. Thank you. Josep?
Todo procedimiento que lo que tenga que ver es asegurar o definir.
Any procedure where you secure or define that object is valid, both at the level of a notary or even in many cases, we have used registration about intellectual property. We make it look as a literary work, when actually the content is the explanation of an industrial secret. Any measure is good as long as you can put a time to it, and you can make it look like there's a date to it and it has an exact content.
Bueno, muchísimas gracias.
Thank you very much.
Muy interesante. Hay efectos de revisar la aproximación, por ejemplo, con clientes locales.
So when you are reviewing the approximation with local clients, and definitely countries like us have very different dynamics. We have small companies, we have innovators, inventors with limited resources, etc.
Esa parte de los costos, Carlos, tú
Talking about the costs, Carlos,
varias capas,
you were saying that there are several layers.
las características generales.
You determined the general characteristics, and you also mentioned litigation. So that initial premise that maybe patents and their protection can be very costly.
Puede eventualmente en materia de secretos, más allá del trámite de notarización eventual.
How do you reconcile that with the secrets?
Una cantidad de medidas muy costosas y el enforcement y el litigio.
You know, it can be very costly. The enforcement, the litigation can be very, very costly. How do you reconcile those two together? And where is the balance tipping to for that specific type of customer? Let's say that maybe the patent is not that long, it's not that costly in comparison to this other alternative. What do you think about that?
Pregunta, independientemente de lo que tal vez Margarita quiera complementar.
Well, I'm going to start. Maybe Margarita wants to add something else later on.
Va a depender mucho de la jurisdicción.
It depends on the jurisdiction. There are jurisdictions where mitigating or litigating secrets is easier than others. In some other jurisdictions, it's almost impossible. You already know you're going to lose from the go. There are jurisdictions where litigating patents, it's also very easy, and in others, it's also very hard. In my personal experience, it is hard to generalize.
Hay que tener la aproximación.
But you always have to give them an approximate figure of cost benefit. It's going to depend on the customer. Many times we see that, yes, to get a patent is costly, not only in Peru, but in other countries. Since it's a territorial right, I have to go to several countries with potential to be able to get the patent over there. However, sometimes the client only needs to want to get a title that they can publish. And with the secret, you don't have all that freedom. And second of all, something that they can sell. Many times the inventor is just an inventor, a scientist. That spends 80% of their time in college, so they don't have the financial support to be able to market, to publicize the product. So what they want is to sell their invention. From that perspective, I prefer to request a patent. Of course, to start the patent and to get it at the end is costly, but like you said very well yourself, to protect a secret a long time can also be very costly. In the case of companies like Sodexo that have international characteristics in regards to the protection of their secrets, I let them know that they failed very big, that would have made them lose the case if the other party realized it. And that is that they left a worker go and they didn't nullify, they didn't cancel his password to the internet. So keeping a secret is also costly. Maybe not at the beginning, but there is a cost long term depending on the industry. And depending on the situation. So I think, I couldn't tell you from the start, yes, I prefer this, I prefer that. You have to analyze on a case-by-case basis and the special characteristics of the client. If you have to make me choose, I prefer a small patent to a big secret. We don't have any more time. We appreciate your presence a lot. We thank you very much for your questions and your attention. Thank you, Josep, Margarita, and Carlos. It's been a pleasure. Thank you, CP, and see you later.